So what's going on with our judicial system in America? Well, lots of questions, not a lot of answers. In family court, there is a lot of prejudice against men. According to FBI statistics several years ago, it was 87.3% of women were getting custody of the child. How is that when women are crying for equal rights? Oh, except for in the family courts. Then whatever happens is okay with them. Well, this is a special message to the fathers, okay? And I'm going to go over this, and there's lots of stuff. I'm going to be dipping into my computer, so I hope to God that I can find the stuff and keep intelligently engaging you while I do this, because there are some things we're going to have to look up, and they're only on my computer, and it's a little bit slow. I do have a new one that I'm waiting to hook up. I'm just waiting for some cables to come in the mail right now so I can transfer all my data. But one of the things is these are all maxims of law, and you can find them on thelawfulpath.com. It's Bouvier's Maxims of Law, and they go over the chiefest of the chief laws. What happened thousands of years ago, 10,000 years ago, when law was first cultured in Persia, Babylon back then, but it's the area that we now know as Iraq. They developed mathematics, and they developed law, different sciences, all came out of that general area of the world then. I'm not going to get into if aliens came down and they enlightened us with knowledge, or if they were just brilliant people. That's irrelevant to this. What's relevant is that they established maxims of law. For instance, you see your kid reaching into the cookie jar. You come home and you go, "What are you doing?" "Nothing." And he's got chocolate and crumbs all over his face. You know he's been eating the cookies. He's trying to grab another one. And he lies about it. Well, they witnessed this type of behavior thousands of years ago, and they established the maxim of law: he who denies admits. So when you deny something in court, you're actually admitting it is true. Now, I've never been able to find that one. I've looked diligently for that maxim of law, and it stands in court. I've defended myself against it, and if you look here on YouTube, my lecture about the 12 presumptions of law is specifically designed to negate all of those presumptions without denying them, putting it in the affirmative. So, one of them is, he who receives the benefit should also bear the disadvantage. That one you can find it CUJUS est COMMODUM. And I'm just giving you that. That's the first Latin part of it, and it's all in Latin at thelawfulpath.com, so you can find it alphabetically. He who receives the benefit should also bear the disadvantage. So why are men paying child support? The women get the benefit of the child. The men have to bear the loss, and never use the word suffer, because according to Black's Law Dictionary, the word suffer is defined as to agree with. And I'll go and get you that in a little while. But since the women get the benefit of the child, they also get the disadvantage of the extra costs, food, clothing, shelter for the child. Why are men paying child support? And it's biased and prejudiced. Read the 14th Amendment and include this in your paperwork, guys, that the 14th Amendment guarantees equal protection under the law. This is also important for the LGBTQ community. And it's also important for women to use it when they say they're not getting equal pay. See, I'm playing both sides of the fence because I don't give a damn about the sexes. I don't give a damn about your sexual orientation. I don't give a damn if you're bipartisan, if you're a Republican, a Democrat, or a Libertarian, or whatever. Don't give a shit. All I care about is bringing you the law, the truth in law. And that is a maxim. I typically put 20 to 30 maxims in every court case that I am a defendant in or for my clientele. This is another maxim of law that is very important for family court. And that's the main concept of this lecture. Even though I drift off into other things, you have to. It is a fault to meddle with what does not belong to or does not concern you. And you will find that at culpa, C-U-L-P-A, E-S-T-I-M-M-I-S-C-E-R-E. Again, continue on in Latin, but you'll find it there alphabetically. It is a fault for judges to meddle in what does not concern them. This is a gift from God, the Almighty, that bestowed upon the two parents the benefit, the greatest gift of the life of a child, and entrusted them to raise it into adulthood. And the courts do not have a right to meddle in it. This is a private agreement. I know they stick it through adhesion contracts, and don't give me that shit. I've forgotten more about the law than most of you people have learned. So please don't try to correct me. I know exactly what I'm speaking of. I'm giving you source so you can find it yourself. And if you know more than me, then you can prepare your paperwork yourself better with this new information. That's my hope. But see, judges don't even have the lawful right to meddle in family affairs. Who gets the kid? And the 14th Amendment guarantees equal protection under the law. I'm going to read it for you again so you know where it's in the clause 2. The first part is where it says what a U.S. citizen is, and basically someone who's born or naturalized and subject to the Constitution. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the states, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. And right there, parents, you can demand 50-50 custody. Now I want to clarify that because 10% of the guys are dirty bastards. They're drunks, they're wife beaters, they're cheaters, they're thieves, drug addicts, alcoholics, whatever. And 10% of the women are whores and cheaters and drunks and drug addicts and compulsive gamblers, and all the obsessions lie on both sides at the extremes. But the other 80% are entitled to equal protection under the law. And it's not just her saying, well, he's a drunk, and because he's a drunk, blah, 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 blah. There's a perfect maxim for that. The burden of proof lies upon he who affirms, not he who denies. So you can ask them to prove your claim that I'm a drunk, prove your claim that I'm a thief, prove your claim that I am whatever they accuse you of. The burden of proof lies upon he who affirms and makes the claim. This is one of the most important maxims of law, and it is found at EI, EI incumbit, INCUMBIT, probatio, PROBATIO. And again, that's the first links of the letter. Et, et. You'll find it there. So when your spouse says, well, you're a drunk, if you go, no, I'm not, you're actually giving her the balance of the scales, where now her case is better than yours. Because she affirmed it and you denied it. The condition of he who affirms is better than the condition of he who denies. I know that looks different because it's the scales. This one holds more weight. If you prefer to see it the other way, of just who's better, the wife says you're guilty unless you're proven innocent. No, that's not the case in family law. It must be turned and flipped. Prove your claim. Don't deny it. Okay, I'll accept that I'm a drunk, provided she can show proof. And she goes, well, here's receipts of all these 10 times that he goes to 7-Eleven every week and buys beer. Okay, prove that you didn't drink half of that. See, it's very difficult to prove a lot of the things, and attorneys have been very tricky, which is why you should consult with me, and I'm more than happy to discuss things with you free of charge to help you out, because there's a lot of traps that they've set in the family courts. That's one of the biggest ones. Now here's a little something that you may not know. If you're a father and want to get custody of your child, better be under a legitimate marriage. You have to be married before she gets pregnant. Before that, like 3 months, so there's no question you were married and then she became pregnant. The timeline must be intact. It can't be that on your wedding night you got her pregnant. Wait months. And this is some knowledge for future family planning. It says, children born there under a legitimate marriage follow the condition of the father. Cum legitimate, CUMLEGITIMAE. And you'll be able to find it alphabetically at thelawfulpath.com from there. Now see, there's a lot of other things that are very important. I find this one, I'm scrolling through these, and I find this one very funny. A madman is punished by his madness alone. Furiosus. Solo. It's FURIOSUS. SOLO. And you'll find it from there. Here's another one. When parties have equal rights, the condition of the possessor is better. INAEQUALIJURE. Very important to parents who want to keep custody of the child. Take the child and go to court with it. They'll threaten you with kidnapping and all that shit until there's a fucking court order. No kidnapping charges can be enforced. So don't be afraid of that. But again, if you're planning on doing that, contact me before so I can give you a bunch of guidelines, because it's outside the scope of this and it's a little bit bigger than this. Here's another very important one, and I'm going to back this up with some case law too, because it's so important that you, if you want to defend your rights in family court, fill out an affidavit. You must have an affidavit. Okay, here's the maxim. Um, In law, none is credited unless he is sworn. And it goes on to say, which is not part of the maxim, but it's tagged to it, all the facts must, when established by witnesses, be under oath or affirmation. Here's the tag. In judicial non creditur. IN JUDICIO NONCREDITUR. Now here's some case law that I've used successfully in court to defend that and to get cases dismissed because cops don't go and write things in affidavits. Group versus FINLETTER 108 F Sup 327 from 1952. All allegations in affidavit in support of motion must be considered as true in absence of counter affidavit. Again, no one is credited unless he's sworn. See, and that's why it's so important, these maxims, because they're the foundation which the courts then, the federal court in Group versus Finlitter, used that maxim to decide that case. That's why they're important. That's why you should study these religiously, because you can use these all across the globe as case law and to support your case. And then United States versus KIS 658 F 2nd 526 536 from the 7th Circuit in 1981. Non-rebutted affidavits are prima facie evidence in the case. Non-rebutted affidavits. No one is credited unless sworn. See, so this really is beautiful. And a lot of people tell me the judges are biased and prejudiced. No, it's 100% your fault. It's 100% your attorney's fault if you don't get what you want in court. Because the courts are so biased and slanted and prejudiced for the people. If you know your rights, you know how to protect them. Let me give you some quick examples of that. Bryers, BRYARS versus United States 273 U.S. 28 from 1927. The Constitution is supposed to be enforced, and the Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. Remember the 14th Amendment, now you're bringing that in. Judge, I'm entitled to equal protection, and Bryers versus U.S. says that it should be liberally construed in the favor of the citizen. What can be more liberal than 50-50 custody? You see how you build your case with these things? Law is beautiful. Governments will try and get you into the court and say, this is not a matter for the courts, this is a matter for us to handle individually. And you can take, my children are 22 and 27, so I can't, but you can take this and actually go into court and remove yourself from the court by challenging jurisdiction. Now, jurisdiction is a wholly, WHOLLY, different issue. Okay, you must, see, they'll go in and they'll say, well, the court has jurisdiction because you're here. So use the 12 presumptions of law affidavit. You have to transcribe that. You can email me, and I'm happy to send out written copies so you can edit them yourself, and they're all on Microsoft Word, and you can do that free of charge. I don't do this because I want to make money. I do this because I want to help. So here's several cases real fast for jurisdiction issues. And this is one of the things I love talking to people and going, Penhollow, Dred Scott, Clearfield, and Bond. They prove 4 times that you must have a contract or other commercial agreement with the courts, with the government, for them to enforce their laws, rules, codes, regulations, and statutes with you. That was supported by Rodriguez versus Ray Donovan in the U.S. Department of Labor, and Flournoy versus the First National Bank of Shreveport, Louisiana. So now I'm going to break all those cases down to you. Yes, I really do understand all this that well. Penhollow versus Dome's administrators cited at 3 U.S. 54 from 1795 at page 93. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, them, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and contracts between them. The flip side of that is how they trick you. That's why the 12 presumptions of law is so important, because it establishes that you're not a corporate fiction, and therefore they don't have jurisdiction. Also, Dred Scott versus Sanford cited cited at 60 U.S. 393 from 1857. The state citizen is immune from any and all government attacks and procedure absent contract. As the Supreme Court has clearly stated, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. It goes on to say a lot more. It's 142 pages of shit. And then, as I said, Clearfield Trust. And this one, Bond versus U.S. used Clearfield Trust, so it's the exact same case. You can shepherdize it and see that's a system in law of using previous case law, like Clearfield, to establish new case law, like Bond. It's called stare decisis. Look that word up in the legal dictionary. It means previously decided in Latin. Clearfield Trust was from 1943, and it's cited at 318 U.S. 363 to 371. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities, checks, is concerned. For the purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. As such, government then becomes bound by the rules and laws that govern private corporations, which means if they intend to compel an individual to some specific performance based upon its corporate statutes or corporation rules, then the government, like any private corporation, must be the holder in due course of a contract or other commercial agreement between it and the one upon whom specific demands for performances are made. That means if the judge in family court wants to tell you you have to obey the laws, where's the contract? Again, the maxim, the condition of he who affirms is better than the condition of he who denies. You don't tell the judge, no, I don't. You say, show me the contract. Penhallow says it, Dred Scott says it, Clearfield says it, and Bond says it. Bond versus U.S. is cited at 529 U.S. 334 to 2000. And you can also look up Colton versus Kentucky, another case, 407 U.S. 104 up to 122 from 1972. So, all those cases. Now, if they're charging you criminally, you might want to also include Rodriguez and Flournoy. So I'm going to discuss those with you real quick. Rodriguez with an S versus Ray Donovan, U.S. Department of Labor, cited at 769 F. 2nd from 1344 from 1985. All codes, rules, and regulations are for government authorities only, not human creators in accord with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process of law, and that they are void for ambiguity in their failure to specify the statute's applicability to natural persons, otherwise depriving the same of fair notice, as their construction, by definition of terms, aptly identifies the applicability of such statutes to artificial or fictional corporate entities or persons, creatures of statute, or those by contract employed as agents or representatives, departmental subdivisions, offices, officers, and property of the government, but not the natural person. Then Flournoy versus First National Bank of Shreveport, a Louisiana State Supreme Court case, 197 LA, Louisiana, 1067, 3 South 2nd, 244. A code or statute is not a law. It goes on to say the common law is the real law, the supreme law of the land. The codes, rules, regulations, policy, and statutes are not the law. The federal courts say this. So there's a lot of stuff in there for you in family court. I hope this was helpful. There's more tricks to it. Never sign anything. Well, do you agree to come back? No. I won't sign that. I'll verbally agree if we don't work things out before. See, that's called a conditional acceptance. And on every commercial presentment, there are only 4 doors that you can do. 2 of them keep you in dishonor, and 2 of them keep you in honor. You can accept their offer. You can conditionally accept your offer, and they keep you in honor. And I'm going to do a special lecture on conditional acceptance and a lot of the things that did it, because I've become really good at that. The 2 that put you in dishonor immediately are to ignore somebody or to argue with them, which is why you don't get into arguments. That's what lawyers do. And they trick you to thinking that that's the way you're supposed to behave. This is a gentleman's game. You're supposed to be very proper, very pomp, well certain, and very polite. You're not supposed to argue. And if somebody gives you an offer, you must either accept it or reject it politely. You can't just ignore it. That's why I tell people, never plead the fifth. Fuck all the lawyers that tell you to shut up and don't say a word, because it immediately puts you in dishonor. And then you've lost. So remain in honor, show up in good faith, do not deny, ask them to prove their claim, and know that you have a right, a natural right, for equal protection of that child. God bestowed it upon you. It's not that the Constitution gives you the right because of the 14th Amendment. The 14th Amendment is a restriction which that judge cannot deprive you of equal protection under the law. Big difference. Get to know this. Watch more videos. You can contact me at my email, tonyfreire702@gmail.com. Again, my name, Tony Freire, Freire, Tony Freire702@gmail.com. Thank you for your time, and I hope I was informative.